Werkstattgespräch im Jahr 2023. Ich freue mich sehr, dass Sie hier sind und dass wir auch heute einen ausgewiesenen Experten in einem aktuellen Bereich, Energiebereich, für den Vortrag gewinnen konnten. Der Vortrag wird auf Englisch sein. Ich werde Sie dann vielleicht auch vorstellen. Ihre Fragen, Interventionen, Diskussionen hinterher, die wir wie immer vorhaben, die können wir auf Deutsch oder Englisch. Also der Vortragende ist Österreicher und daher perfekt multilingual in der Lage, auch Ihre deutschen Fragen entgegenzunehmen. Bevor ich den Vortragenden ganz kurz vorstelle und sein Thema, möchte ich noch Dank aussprechen, weil das hinterher immer zu kurz kommt. Erstens dem Sponsor, der Kanzlei J.R. Hempel, hier vertreten durch Hans Christopheritsch, die uns das reichhaltige Buffet ermöglichen durch ein großzügiges Sponsoring. Ganz, ganz herzlichen Dank, lieber Hans. Zwar nicht nur für diese Veranstaltung, sondern für die Werkstattreihe insgesamt. Und zweitens dank meinem Team, das da hinter der Säule steht, nämlich Elisabeth Schweiger, die uns leider zu Jahresende verlassen wird, und auch Johannes Lukan, der hier hauptsächlich, vor allem dann auch, wenn die Technik abstürzt, immer wieder einspringt. Und also auch euch ganz, ganz herzlichen Dank für die Organisation und die Mitarbeit. Vielleicht so. Das war es aber schon. Also, der heutige Vortragende ist Dr. Ernst Tremmel. Wie gesagt, Österreicher, das an sich wäre noch nicht hervorhebenswert. Hervorhebenswert ist gleichwohl, dass er ein Alumnus ist dieser Fakultät, was mich sehr freut. Hier das Magister, ich glaube auch das Doktorat absolviert hat, aber auch studiert hat in den USA, in der Columbia, also an der Columbia University, Columbia School of Law. Und auch im Zuge dieser Studien auch die Anwaltszulassung sowohl in New York als auch hier in Österreich erworben hat. Er ist seit Etablierung der Agentur ACER, also Agency for the Cooperation of Energy Regulators, und diese Agentur wurde im Jahr 2011 errichtet und seither sind sie dort auch tätig. Als Legal Advisor mit Fokus auf den Elektrizitätssektor. Herr Dr. Tremmel war davor lange Jahre in der anwaltlichen Praxis tätig, nämlich im Wesentlichen seit Ende der 90er Jahre. Ich würde hier stehen, 98 lese ich hier als ältestes Datum, also zunächst in Österreich, wenn ich das richtig verstehe, und dann in Brüssel in den Feldern Energierecht, offenbar natürlich, also Wettbewerbsrecht auch und öffentliches Recht, und davor hat er einige Praxisstationen am Europäischen Gerichtshof, aber auch am Legal Service der Kommission und auch am European Institute of Public Administration absolviert. Also, umfassend ausgewiesen, nicht nur in dem Bereich, in dem Sie heute vortragen, sondern auch akademisch, praktisch, im Grunde der Idealtypus der Anwendung des Europarechts. Und heute konnten wir ihn gewinnen, und ich freue mich sehr auf Ihren Vortrag zum Thema Regulating EU Energy Markets in Turbulent Times, the Role of ACER. Und ich freue mich sehr auf Ihren Vortrag, den wir, wie stets, nachdem Sie sich bitte nicht gedrängt fühlen, also in Ihrer eigenen Zeit, dem Vortrag gelauscht haben, mit einer Diskussionsrunde abrunden würden. Herr Dr. Tremmel, bitte um Ihren Vortrag.
Vielen Dank für die netten einleitenden Worte und vielen Dank überhaupt für die Einladung. Es ist nicht so selten, dass man aus Laibach jetzt nach Wien kommt zu einem Vortrag, weil die Agentur jetzt nicht, also selbst in Laibach, nicht mal so bekannt ist und vielleicht in den Mitgliedsländern. Aber vielen Dank jedenfalls für die Einleitung. Also Entschuldigung, ich werde den Vortrag auf Englisch halten, weil ich die Folien auf Englisch habe und es ja sehr viel Arbeit wäre und teilweise auch sehr schwierig, das alles umzugestalten in der Kürze der Zeit, die mir zur Verfügung stand. Und zum anderen ist es dann für Sie leichter, das zu verfolgen, was hier auf der Folie steht, wenn ich jetzt mit deutschen Begriffen komme, die Sie vielleicht nicht so sehr mit der Folie assoziieren. Wenn etwas nicht klar ist an den Begriffen, dann sagen Sie es mir bitte. Ich versuche so gut wie möglich, das ins Deutsche zu übersetzen. Und natürlich in der Diskussion Fragen bitte auf Deutsch oder auf Englisch, wenn Sie wollen. Ja, wie gesagt, the topic is regulating EU energy markets in turbulent times, and I was asked to present the role of ACER in general, but then also to discuss or highlight some of the current issues on which ACER is working during the energy crisis. So actually, I would start with this, how was the agency established, what is its mission, and actually an important part of its functioning is how is it governed actually, what is its structure, because it's a bit difficult, atypical from the usual governance of EU agencies. Just to give you a glance of the development of energy regulation in the field of electricity and gas, and that's very important to highlight electricity and gas. ACER is working on electricity and gas. It's not working on oil, for example. So these are the energy sources with which ACER is dealing. And as you can see from this overview, first package, the partial liberalization of the energy markets, second package with the establishment of the NRAs. Since 2003, national regulatory authorities, NRAs, play a very important role in the regulation of energy markets. They are actually key. And this is also the reason why ACER has been established, because at some point, with the liberalization of the energy markets, cross-border issues became more and more relevant. If cross-border issues become more and more relevant, cross-border regulatory activities become more and more relevant, and there is a need to coordinate these regulatory activities. And that's why ACER has been established, and this was in 2009. Before, you can see it at the bottom, there is something called CER. This is an association of the national energy regulatory authorities, so it's an association under Belgian law, where they exchanged, it's actually the voice of the national energy regulators, where they exchange best practices and act on an international level. In 2003, there was ERGEC, which is the acronym for Energy Regulators Group for Electricity and Gas, which is an advisory group established by the European Commission to actually deal with the increasing cross-border issues. The Commission asked for advice by national regulators, which were part of this ERGEC group, in order to further harmonize cross-border rules and cross-border regulation. At some point, however, it turned out that this loose concept of ERGEC is not enough to deal with the specific issues. That's why the Commission decided to increase actually the cooperation of national energy regulators and thought about what kind of concept or mechanism could be suitable. It thought about doing it itself. It thought about other concepts. In the end, it decided to establish a specific agency. So, European Union Agency for the Cooperation of Energy Regulators. There is constant discussion. What is actually what type of agency is it? In terms of, is it more cooperation or is it more regulating? Because as you will see, that the basic concept of ACER's functioning is the activity or the involvement of the national regulatory authorities. In terms of its nature, it's a decentralized agency of the European Union, as so many others. You can see it on the map, the plethora of decentralized agencies. As such, it has its own legal personality. It is distinct from the EU institutions, but accountable to them, and is governed by public law. Established 2009, seat is Ljubljana, capital of Slovenia. Current staff number about 136, and the budget about 30 million. And part of it is paid by so-called remit fee. That's a fee that market participants have to pay in order actually to be surveilled for their trading activities. I will address this a bit later. The mission. What is the mission? To foster a fully integrated energy market and providing a platform for the NRAs to cooperate and coordinate their activities. As you can see here on the slides, the mission of ACER expanded over time. Initially, the focus was indeed on the cooperation of national regulatory agencies, authorities. In the course of time, it turned out that ACER is actually playing a very active role, or maybe active is not the precise role, but an important role in mediating and settling disagreements between national regulatory authorities. I will come to this also a bit later. And it contributes to best practices in terms of regulation and supervision. It acts independently and it takes autonomous decisions. Now to the governance structure, which I said is in principle based on the same institutional setup and the same governing principles as other EU regulatory bodies. However, unlike the common approach, and that's in the left corner, there is no management board as other decentralized agencies of the Union do have. So there is no management board with comprehensive decision-making power. In contrast to other decentralized agencies, the agency has a board of regulators, which plays a key role in the entire regulatory work of the agency. So just to go briefly through the various bodies of the agency. There is the director, which is who is the formal head of the agency. He represents and manages the agency. He prepares and adopts and publishes all the deliverables, subject to a favorable opinion of the Board of Regulators. So that's where the Board of Regulators come in, which means the director cannot adopt any of, or let's say most of the opinions, recommendations, or decisions which the agency issues without, and now I phrase it in more layman's term, without the consent of the Board of Regulators. In legal terms, it's an opinion which the Board of Regulators has to provide. If the Board of Regulators does not agree, the director cannot adopt the relevant opinion, recommendation, or decision. He prepares the work program, prepares and implements the budget, and he should act independently. So he is not subject to any instructions from union institutions, governments, or other entities. The administrative board, that's the governing body in terms of administration, budget, and institutional matters, 9 members. Non-voting members from the EEA EFTA states, NRAs, and its task is actually essentially to ensure that ACER carries out its duties and its mission in accordance with its founding statute. The Board of Regulators. So that's the supervisory body within ACER. It consists of representatives of the national regulatory authorities. 27 regulatory authorities means 27 voting members. They vote with a 2/3 majority. And as I said, they provide opinions to the director on ACER opinions, recommendations, and decisions. In practice, this means, as I briefly mentioned before, the director cannot adopt a decision without a favorable opinion of the Board of Regulators. Initially, there was no way to dissolve any blocking situation. So when the Board of Regulators disagreed, there was no way to overcome such a situation. Now, since the last revision of the ACER regulation, the Board of Regulators was granted the right to amend the proposals which are sent to him for a favorable opinion. But nevertheless, even then, the director is not bound on these amendments. So if there is a disagreement between director and Board of Regulators, no act can be adopted. An important element is that they also need to act independently, do not follow any instructions from their governments or other private entities. However, this is without prejudice to their affiliation with the national regulatory authorities. So the fact that they act on behalf of the national regulatory authority does not make them independent or biased. Actually, it's accepted that they act in the interest of the national regulatory authority, which, as you can imagine, leads to different interests when deciding or voting on different proposals. Board of Appeal. Very important structure in terms of the regulatory process, in terms of decision-making. The Board of Appeal made up of 6 members, current or former senior staff NRA members. Currently, the chair is a former judge of the General Court. 2 law professors are also sitting on the Board of Appeal panel, and further technical and legal experts. The Board of Appeal decides on ACER decisions, so only binding acts, no soft law measures which can be appealed before the Board of Appeal. And its competence is to confirm the decision or to send, if it agrees with the appeal, to send it back to the relevant body of the agency, which is the director, which then needs to follow the decision of the Board of Appeal. So it's a kind of internal review body. The next step after the Board of Appeal is Court of Justice, General Court, Court of Justice. And what is important, you can only approach the Court of Justice after you exhausted the internal review process. So appellants are not allowed to directly address an annulment action against an ACER Act before the Court of Justice, but only after going through the internal Board of Appeal procedure. This follows, so for the lawyers, this follows from Article 263 of the treaty, where there is a provision which states that a legislative act establishing an agency can provide for specific conditions and arrangements under which natural or legal persons may contest an act of the agency, which actually is the case in case of ACER, which on the other hand also gives rise to an interesting question, which is currently pending before the court. As you can see, this relates to natural or legal persons. There is no clear statement what happens actually with regard to annulment actions by member states. According to the treaty, it's not covered. According to the treaty, you're a privileged applicant. You would be allowed to immediately challenge an ACER decision before the Court of Justice, which is actually the case in one of the pending cases. So for those who want to follow it, it's T283/19. The Republic of Germany challenged an ACER decision without going to the Board of Appeal, because the follow-up question is actually a member state allowed to go to the Board of Appeal, which is not specified in the ACER regulation. So in order not to forgive any option to challenge the ACER Act, the Republic of Germany challenged the Act directly before the Court of Justice. It's still pending. It has been suspended because in parallel there was a Board of Appeal proceedings which was launched by the German regulator. So the German regulator challenged the same decision before the Board of Appeal. The Board of Appeal decided, and the German regulator challenged the Board of Appeal decision before the General Court. Republic of Germany did not challenge the Board of Appeal decision. The second question is, could the Republic of Germany challenge then the Board of Appeal decision without being involved in the underlying Board of Appeal case? Fact is, this is an issue still pending before the General Court, and to make things even more complex, in the meantime, this decision of the Board of Appeal, which has been challenged by the German regulator, has been annulled by the General Court. The Board of Appeal issued a new decision, which now has been challenged by the Republic of Germany as well. So now the Republic of Germany has two lawsuits pending, one against the initial ACER Act and one against the Board of Appeal decision. In terms of, I hope I do not spend too much time, but I think for the lawyers it may be interesting because with regard to the Board of Appeal, there are interesting cases which also clarify the competence of Board of Appeals in general, which means what is the scope of their review. And here the General Court emphasized that the Board of Appeal needs to assess, to run a full review and cannot limit itself like the court does just on the manifest errors. So there is no way for the Board of Appeal not to scrutinize the entire case, regardless whether it's a manifest error or not. However, it does not need to review the case from scratch. It reviews the case within the boundaries of the pleas and arguments raised. And the last comment on the Board of Appeal is with regard to the appealable acts. There is currently a case pending, and this refers to the third paragraph. I think it's the third on the regulatory act. You can appeal regulatory acts before the General Court or Court of Justice. However, there is no specific provision in the ACER regulation that you can do so also before the Board of Appeal. The Board of Appeal decides on decisions, and now there is a case pending before the General Court where the Board of Appeal dismissed an appeal, arguing this is not an ACER decision, but it's a regulatory act. And the appellants now challenged this qualification, saying, well, it's actually a decision, but the court may decide also on the option of or the obligation of ACER to decide on regulatory acts. Okay, working groups. I will just mention that there are 4. They prepare the work for the Director and the Board of Regulators. The work in general, just to give you an overview on the landscape within which ACER acts at European level as a regulator. You have ACER at national level, the national regulatory authorities. The next column is actually the regulated entities, ENTSOs. These are the European network of transmission operators, a kind of association or representative association, which facilitates the cooperation, coordination of the transmission system operators, those who run the pipelines or the electricity grid. At regional level, there are new bodies which were created with the last revision of the electricity regulation. These are regional coordination centers. They support the transmission system operators only for electricity in their work. And then, of course, at national level, we have the transmission system operators. At EU level, the last column is a similar entity as for the transmission, so the high voltage level lines. You have it also for the distribution system operators, an entity coordinating the DSO activities, and then an acronym NEMOs. These are the nominated market operators, nominated electricity market operators, also only relevant for electricity. They are responsible for actually the market, the electricity market and the trading functions and runs. The last introductory slide is on the different modes how to regulate on European level, because it's also not so obvious, let's say, from the textbook. Of course, you have the legislative acts, regulations, directives, delegated implementing acts, depending on whether you supplement or amend the non-essential elements, and or whether you set uniform conditions to implement the legislative acts. And for electricity and gas, this means the delegated and implemented acts, they are framed as network codes and so-called guidelines, which establish the technical and the market rules for the market participants, in the first place for the transmission system operators or the nominated electricity market operators. So these are technical rules adopted by the Commission as either delegated or implemented acts, and the starting point are framework guidelines which present the principles on which those network codes and guidelines the network code should be drafted. Then follows a proposal by the representation of the transmission system operators, which is then revised by ACER and sent to the Commission, but in the end it's the Commission's prerogative to adopt the network codes or the guideline. The difference between the two in substance is the network codes are assumed to apply as such. For the guidelines, they require further implementation or specification, where it was felt that the rules as such are not yet clear or can only be established at a higher level and need some further specification. It was decided to leave it to the market participants, to the TSOs or NEMOs, to establish these rules, however, subject to approval. And that's the next step, where terms and conditions are developed, again, market rules, how to operate the system, how to run them, market operations, which are proposed by the relevant bodies, TSOs and NEMOs, and then approved by the national regulatory authorities or ACER. Activities, in principle, I think it's a trinity of monitoring, which was the starting point for ACER, monitoring the market, reporting on the effects and the development of the internal energy market, providing advice to the Commission, to the Parliament, commenting on proposals or deliverables of the transmission system operators, and the decision making. All this based on the cooperation of the national regulatory authorities, in particular in the form of the activities of the Board of Regulators. In terms of areas, or maybe just one step back on the decision making, it's important that initially the concept of ACER decision making started as a subsidiary concept. Initially, the idea was that in the first place, national regulators should decide on cross-border issues where they need to coordinate. They should reach an agreement. If they cannot reach an agreement, or if they would like to do so, they have or can refer the case to ACER, and then ACER decides. So it was a kind of subsidiary decision making. With the clean energy package, this is this mediation and settlement. With the energy package, this changed because there it was recognized that for certain decisions with a certain scope, namely European-wide, it makes actually sense that there's a European body to decide. So for pan-European decisions, in particular for these pan-European terms and conditions and methodologies, it's ACER's competence now to decide, whereas for regional decisions and national decisions, of course, it's obvious, the national regulators decide. But that's important to have in mind, this concept of subsidiarity, and in principle, it's still the NRAs. Market integration. So the work in market integration is drafting framework guidelines. These are the general principles, then reviewing drafts of network codes, approving terms and conditions and methodologies, which decision form actually most part of ACER decisions. I don't know the exact number, but that's most of the decision that ACER takes. Then, of course, one needs to monitor how the network codes and the guidelines are implemented, and provide reports on the successful monitoring of implementation. In that respect, also relevant to note in terms of subsidiarity, it's still the national regulators who enforce. So if there is a finding of non-implementation at national level by a stakeholder. It's not ACER who enforces the non-implementation. Even if it's an ACER decision, it's the national regulatory authorities who have to enforce it. Then there's a general competence to deal with any kind of cross-border issues requiring a joint decision by more national regulatory authorities. And then a very broad competence with regard to the integration of the energy markets, to check what is the development of the integration, what are the barriers for further integration. That's a big chunk actually of ACER's work. Security of supply. This both applies to both electricity and gas actually. Involved in resource adequacy for electricity. Well, here it refers obviously just for electricity. In the clean energy package, there was a requirement to assess for the European network of transmission system operators the resource adequacy. Is there enough generation resources available to meet the demand of European economy and citizens? And here ACER is involved in first providing a methodology. How do you assess it? And secondly, every year there needs to be such an assessment, and ACER then evaluates the assessment provided by the transmission system operators. Risk preparedness, so that's the long-term resource adequacy scenario. Does it meet the needs for in the long run? How the resources available in the short run? This is the risk preparedness. Capacity mechanisms means you hold resources available for the case you need them, and you pay them to be available. That's capacity mechanisms, and there ACER specifies the conditions for cross-border participation in capacity mechanisms. Two new tasks: liquefied natural gas benchmarks and price assessment, in order to reflect that tasks which have been assigned to ACER during the energy crisis, in order to reflect more accurately and more correctly the price, the real world price for liquefied natural gas, and then a market correction mechanism for gas, which I will address later. Infrastructure development. Here it's about also providing opinions or even issuing decisions. EU-wide network, 10-year network development plans, the transmission, the ENTSO-E, so the ENTSO for electricity and the ENTSO for gas. They have to establish network development plans, factoring in the scenarios, the possible needs for investments, which are then reviewed by ACER, and ACER provides an opinion. Projects of common interests or mutual interest, important projects to complete the internal energy market. These are infrastructure projects running across borders. In the first place, electricity. Here also there is a list, a draft list, which establishes which project should benefit from this status, which means if you acquire the status, you can get European funding. You have a simplified administrative process for granting permits, and secondly, you are also eligible to have your costs allocated across the borders, so that your costs are subsidized through tariffs from other member states, which requires a decision. There ACER comes in. If national regulators cannot agree how to allocate the costs, ACER decides on how to allocate these costs to the member states concerned. Congestion revenues use, so where there's not enough capacity on a line, you get congestion revenues from the congestion, and there is a definition how to use it, which is decided by ACER. And the ACER also establishes best practices for transmission tariffs. Finally, a very important field, wholesale energy market integration transparency. Maybe some of you heard it already by the acronym REMIT, which is Regulation on Wholesale Energy Market and Transparency. Here it's about providing or ensuring a fair competition in trading with in energy products. And here ACER is involved in the monitoring of this trading, which means it established a register of market participants who are active in this field. They have to register. They have to provide data which ACER collects, analyzes, and shares with the NRAs. And then ACER provides a monitoring from the European perspective, whereas the national regulatory authorities monitor the market on the national level. And obviously there is cooperation and coordination with NRAs. ACER notifies NRAs about suspicious events, and ACER also provides operational assistance if NRAs investigate, and it coordinates cross-border investigations. There may be, most probably there will be a change, because there's been a change in terms of ACER receiving more competences. There has been a political compromise recently about expanding ACER's competence to the effect that ACER can also investigate on site even cross-border cases of non-compliance or infringements of the wholesale energy market integrity and transparency, which means either it's market manipulation or attempted market manipulation or insider trading. So in the face of the electricity crisis, I just picked some examples of what ACER actually was doing during the electricity crisis. It's only a personal selection, may not be representative to what other may consider important, but just to give you an idea of what ACER does in the different fields of advising, monitoring, and deciding. In terms of advising, I think one of the most important deliverables was a so-called assessment of the EU wholesale electricity market design in April 2022, which was triggered by a request from the European Commission to ACER to assess and analyze the functioning of the wholesale electricity market. In essence, ACER came to the conclusion, well, it's worth still keeping the electricity market. In principle, it sends the signal that the market should send. Irregularities were actually caused by price shock and other unexpected events concerning nuclear power plants in France. But it emphasized the importance of the wholesale electricity market. Still, there are some things which can be improved. I listed them here. I will not go into all of them. And in the end, ACER recommended certain measures for the policymakers in order to improve or make the EU wholesale electricity market future-proof. And as you can see, it's not by coincidence that number one is speed up electricity market integration. One of the recommendations was indeed to, while it's worth keeping the market, it's still worth improving the forward market. So the market in the long run, which is 1 year to 4 year trading in electricity. And based on this finding, ACER then followed up this year with a policy paper on how to develop the electricity forward market. There are different time frames. You have balancing, which is actually real time to balance any imbalances in the system. Then you have intraday, which, as the name indicates, is within a day. You have day ahead, 12 hour noon before the next day, and then you have the longer term, which is up to 4 years. And here is identified fragmentation and lack of integration in this market segment, and proposed in particular to create virtual trading hubs. This may sound very technical. I will not go into the details. It's just to give you an idea of what ASA actually, how ASA developed its findings. Another monitoring activity was the monitoring of emergency measures, which the member states adopted in the wake of the energy crisis. And this report lists more than 400 emergency measures for electricity, and summarizes them and tries to provide to establish lessons which could be taken for the future. The report showed that 33% aimed at security of supply, and only 27 were targeted to vulnerable consumers. So one of the key messages was, if you adopt emergency measures, then they should be tailored and targeted. You can see here there is also an overview how the emergency measures, which I mean, to whom they were addressed, and most of them were direct support to consumers. So one important finding among the several findings is at stake was 646 billion invested in emergency measures, and at the right-hand side, an important conclusion was it's important to have sufficient capacity for cross-border trading, because this mitigates the effect of volatility and therefore also strengthens the resilience of the entire energy system. Cross-border trade, which brings me to this slide and also the next topic, which, if you have cross-border trade, then this is essential for integrated energy markets, and the findings of this report clearly show the benefits of having an integrated energy market compared to isolated energy markets. The price volatility in the national isolated markets is much higher than in integrated energy markets. That's also why the Clean Energy Package 2019, and that's the electricity regulation, identified that the lack of cross-zonal capacity, so the lack of the lines between different trading zones, is a very serious barrier to electricity market integration. The idea of an integrated market, or the idea of bringing the most social welfare to consumers, is you buy where it is, you buy where energy is produced in the most efficient way. And for doing so, you need to trade across border, which requires enough capacity, and there is a limit on capacity. So it's not indefinite, and then the question is, how do you use this capacity? And for that reason, the Clean Energy Package required the member states, and then of course also the operators of the transmission line to provide 70% of the capacity for cross-zonal trade, so for cross-border trades, subject to some deviations, because for some member states it's still not feasible to reach it in a certain period of time. Therefore, you have derogations, you have a trajectory, an action plan until when you should reach the 70% target, but it's an important factor in the entire discussion of the electricity market, the 70%, which you need to reach by the end of 2025. It's key to cope with the increasing feed-in of renewables. If the lines do not offer enough capacity in order to transport renewables, wind from the north to the south, we will fail to reach the climate goals, actually. At the same time, the 70% are also relevant because you will not be able to expand and speed up with the grid investments. Grid investment takes some time. You cannot build transmission lines as quickly as you may be able to adjust the limit of the 70%, not at least for the reason that no one wants such transmission lines in its backyard. So the key findings of this report was, as you can see on the map, the situation is dispersed in Europe, and most of the member states are still far off from reaching this 70% target. There's a large number of action plans, so they reach it hopefully by the end of 2025, but not at the moment. And still you have derogations that you do not apply it at all, even without an action plan. There are still the old barriers, so-called loop flows, that electricity seeks its own way, so it doesn't stick to the line. Remedial actions, these are actions in order to cope with congestion. So either you feed more in, you take something out, you provide counter tradings in order to relieve the congestion which follows from the commercial trades, in order not to have the line overloaded. This costs, of course, and there is no mechanism in place to share the costs of relieving one's congestion. So there are certain lines which are over congested, and if you have to relieve it, then someone has to bear the costs, of course. The recommendations in that context were, speed up grid investment. Of course, this takes time. Improve bidding zone design, which means you trade between zones. Within the zone, you don't have you can actually trade without allocating capacity, which means you do not have any restrictions on capacity. The restrictions occur on the border. There it becomes crucial, unless you change the zone, of course. If you have one big zone and you assume, and this by nature assumes that there is no congestion in this zone, but actually there are lines with limits, this can push the internal congestion to the border, which means it impacts then the trade for other countries. And the relief measure would be to redesign the bidding zones, as it happened some time ago for Austria, where there was a split between Austria and Germany. Use of all remedial action. Okay. So market correction mechanism. This relates to gas. This was one of the emergency measures adopted in the end of 2022 on the basis of Article 120.22 of the treaty, so exceptional procedure for emergency measures. It's an instrument to limit the price in EU gas markets in order to protect citizens and economy against excessively high prices. It's in place for 1 year. It sets a bidding limit on certain financial derivatives, and it is activated when two conditions are met. So one is the virtual trading price needs to be above a certain level, and they need also be above the import price for liquefied natural gas. What does ACER? It assesses the market effects from the introduction of this mechanism. It activates or deactivates the limit, and it monitors the effect. The first report was issued March this year. The finding was no significant impacts that could be unequivocally and directly attributed to the adoption of this mechanism. ACER found no need to revise the price references, no technical reasons to change the current activation. However, it cautioned and emphasized to regularly monitor the market and trading activities in order to identify the risks and to detect potential impacts, negative impacts of this mechanism in the future. Finally, one decision which I consider relevant in the terms of energy crisis and in particular prices. This was a decision about setting a price limit, which for European law is not so obvious that you set, or competition law, that you set price limits. But there is a provision both in the electricity regulation as well as in the underlying network code guideline, which provides for it to have price limits for the clearing price, so where demand and supply, the price where demand and supply meets. And there was an automatic mechanism to adjust these price limits. And the risks with expected high prices in the course of the energy crisis was that there will be frequent increases of this price limit, automatic increases, which means instead of having moderate prices or preventing extreme increases of the clearing price, the opposite would occur, which could have endangered the security of supply during the winter. So this was last September 2022, and it was even more important because there were already incidents in France and in the Baltic area where this price limit, the automatic trigger, was already reached. So what was the solution? ACER urged the NEMOs who are responsible for developing this methodology about how to specify this mechanism to change the current methodology, which means they had to submit a proposal to ACER. ACER reviewed the proposal and then approved it subject to some changes. And the idea was to limit these cascading effects of increases and have repeated extreme price increases while still preserving the benefits of adjustments and the benefits of moving prices. So, outlook. This is already my closing slide. So that's the outlook against which ACER thinks it will operate in the future. There are certain drivers for in the energy market. There are massive changes, not only because of the transition to clean energy. There are changes in the regulatory landscape, and still we need to get used to high prices or to price volatility. The question is then more: is it a question to prevent high prices or price volatility, or rather how to manage the price volatility in the future? The challenges concern the network code, the guidelines, REMIT, 10E. This is infrastructure, security of supply, of course, clean energy, and the strategic goals on top priorities to promotes the completion of the internal energy market, infrastructure and security supply challenges, again, REMIT in order to ensure trust in the trading of energy products and to address the long-term regulatory challenges. Here I would stop my tour de force of running quickly through to some activities of ESA. I hope I gave you an overview. If you have questions, please go ahead.
Thank you very much, Mr. Tremmel, for the dense, for me, very insightful presentation part that I couldn't follow because indeed the technical details were too complicated. But I think there's a number of fundamental, also legal questions in the presentation, and also a number of interesting current topics that we could discuss. I would therefore proceed to the discussion, and I'll probably will collect questions. I'll probably start with a simple question. You're also connecting to your last slide, where you had so many challenges. So are we prepared for winter is my simple starting question, because when I heard you give your presentation, the white paper, the recommendations, also the, if I may paraphrase this, the ineffectiveness of the price correction mechanism, that actually painted for me a relatively depressing picture of too little moving forward too slowly, and also the market correction mechanism that was long, it was heavily debated, but long demanded, and eventually it came, and now it looks like this is also not fit to address the pricing problem. So from your slide, I also saw that prices compared to 2021 are more than double, or maybe even triple the price of 2 years ago. So to sum this up, are we prepared? Could there be, which one of the challenges do you think is the most pressing? Which would be the one area or the 2-3 areas where you think that we should move forward more quickly?
I would rather relate it to the strategic goal. So it's the completion of the internal energy market, because it's also the challenge is, well, how do we cope with the needs to ensure an effective transition to clean energy? That means you will have at the moment a limited amount of transmission capacity, and how do you manage to feed in and to replace, let's say, current power plants by renewables. And there, this raises the question of the infrastructure needs. How do you cope with the new challenges in terms of more feed-in quantity, and this then relates to how to address the difficulties in the short to mid-term run, which means providing sufficient capacity on the lines at the moment, and on the other hand, to provide more flexibility to the system, that the system becomes more flexible, that consumers react with flexible demand. I think these are the challenges in terms of gas. Well, I'm not a gas expert, but I think one can also the market correction mechanism or the findings could also be read in the light that maybe the conditions are still sufficient, since they were not triggered, or no new limits were set. This does not mean it does not work. It may perfectly work and the limits were set actually at the right level.
Right. I apologize by the way, for the sound of construction in the background. It's all over the house and has been for more than half a year, so I'm sorry. I would have a follow-on question, but probably first, Gesandter Meissel.
Vielen Dank für den Vortrag, der also mir sehr viele Türen geöffnet hat. Ist es doch, wenn man sich die Judikatur anschaut, immer wieder durchaus im Spannungsfeld. Das ist meine erste ganz prosaische Frage. Wer vertritt ACER dann in den doch relativ vielen Verfahren? Machen Sie das? Und die zweite Frage, die ist eine ganz andere Art. Wenn ich das richtig verstanden habe, ist der vollständige Energiemarkt auch sehr stark angebunden an eine entsprechende Infrastruktur. Ist das eine geografisch europaweite oder immer noch eine EU-zentrierte Infrastruktur? Also bauen wir durch den Balkan oder bauen wir rundherum? Sowohl regulatorisch als auch mit der Infrastruktur.
Ja, zur zweiten Frage. Also ich muss gestehen, da ist ein zentrales Element diese PCI-Liste oder PMI-Liste, diese Projekte von gemeinsamem Interesse oder von gegenseitigem Interesse. Die Projekte von gegenseitigem Interesse, die betreffen jetzt auch Drittstaaten. Also die Projekte von gemeinsamem Interesse, das waren EU-Projekte, jetzt wird es erweitert auch auf Drittstaaten. Ich kenne jetzt nicht die Liste, aber das weist schon in die Richtung, dass man jetzt nicht an den Grenzen aufhört und auch Projekte, die außerhalb der Grenzen beginnen, in den regulatorischen Rahmen mit einbezieht. Und wenn Sie jetzt unsere nahe Nachbarschaft nehmen, es gibt die Energy Community, die im Übrigen ihren Sitz hier in Wien hat und die Balkanländer mit einschließt, zusätzlich mit Ukraine, Georgien und Moldawien. Und die haben sich verpflichtet, bis Ende des Jahres das Clean Energy Package umzusetzen. Da geht es jetzt noch nicht um die Infrastruktur, aber zumindest der Markt wird jetzt auch in diese Länder exportiert und die haben sich verpflichtet, diese EU-Regeln in ihr Rechtssystem umzusetzen. In dem Zusammenhang wird ESA Entscheidungsbefugnisse haben über diese Länder. Und zur ersten Frage, ja tatsächlich, also, ich habe am Beginn vertreten, irgendwann wird es zu viel, weil also die meisten Fälle sind Strom. Es gab nicht sehr viele Juristen, die sich dem gewidmet haben in der Agentur. Also wir sind nicht sehr gut ausgestattet gewesen. Die Fälle waren noch dazu auf Deutsch. Also hat sich irgendwie angeboten. Aber mittlerweile teilt man sich das mit Anwälten auf, weil es einfach zu viel wird. Wenn es ein Fall ist, dann geht es, wenn zwei, ja auch noch. Aber wenn dann 8 Parteien gleichzeitig klagen, 8 Schriftsätze in 3 bis 4 verschiedenen Verfahrenssprachen, wird es nicht mehr machbar.
Vielen Dank. 2, 3 Wortmeldungen haben wir.
Thank you very much indeed. Next, Grauenberg Institute for the Danube region in Central Europe. I've been serving for Southeastern Europe for years, and I saw this progress quite enormous. I don't know if you were involved, like the interconnector to Bulgaria, North Macedonia, or the Krk LNG plant. So I wonder if you were giving some advices, or it was purely a thing of member and non-member states. But closer to us in Austria, we have the problem of 40 kilometers missing to Germany for a reverse flow system in gas. Now the gas question, we have it with Italy, but not the capacity. So I wonder if there was also a responsibility of the government as such to assure the trade of sufficient gas, as we must think end of next year, the transit via Ukraine may stop. We don't know, but it could. And this is a risk for companies, of course. If not, it could be a stranded investment. Now, I would like to know your opinion and if you are giving any advice on it. And the other thing is more general, especially for the electricity market and the energy transition. It is the legal situation. The legal process in Europe is extremely slow. It takes 10 years to have a high tension line. This way we will not reach the targets, that's for sure. Now I wonder if ACER or the EU is urging a faster process, or also the member states, otherwise we'll not reach the goals. Thank you.
Yeah, I think on the very first question, I'm not a gas expert. I have nothing to do with gas. That's why it's difficult for me to comment. But I think in general, one general comment, which may also relevant, there are the 10-year network developments plan, which is both true for gas and electricity. But here I see a role in the sense for ACER that it comments and can give advice in terms of which investments are needed. But otherwise, from an agency point of view, it's hard to require member states to build lines, which may make sense.
All right, thank you. Hans Christopherich and then Professor Tosserk in the order that you raised there.
Thank you for your presentation. I just wanted to come up with one question regarding a specific topic as regards market design, because you said that you had some recommendations, or ACER had some recommendations, and that slide was quite quickly, so I couldn't read everything which was on that slide. And my question was that there's one specific problem, whether I wonder if ACER has competency or whether you dealt with that, when you are a energy supplier, a municipal energy supplier, and you trade in energy at the exchange in Leipzig, you need to deposit collaterals. And for that, there was a specific part even in the temporary crisis framework under state aid law. And I think many member states, such as Finland, Germany with Uniper, but also here the city of Vienna, they had to give very high subsidies in order to assist their municipal energy suppliers. And I think that could have been avoided if there would have been some type of regulation into that stock exchange, or that exchange, energy exchange, so that the prices couldn't have risen above certain thresholds. And I wonder whether ACER has also thought about that in their recommendations.
What I'm aware of is that the issue of collaterals is currently a pending issue of an ACER decision in the terms of harmonized allocation rules. And this question is actually reviewed in this context. But in the recommendation itself, it's picked up, I think, in terms of in the context of the forward policy paper, but I'm not sure about about these recommendations.
Thank you.
Thank you so much. Thank you also for interesting presentation. Actually, my question is connected with your question, Mr. Meisel. You have mentioned already before that there are many action for annulment at the General Court. Could you explain how many, if you have this number? Because I spoke with some judges at the General Court, and they are, how to say, worried about so many new cases in this area, because there are the problems that they have a majority of new cases also in other areas, especially the area of restrictive measures and EU sanctions against Russia. There are so many Russian oligarchs, and they have started already procedure with action of annulment, and now also energy market with other. So that if you have the number, this is for me just to compare. And the second question: how is your cooperation with energy community? Do you have direct cooperation also? As I'm active also with the energy community, but or is everything how to say via European Commission?
No.
Thank you.
The energy community first. Well, the energy community in one of its body is the Energy Regulatory Board, and there is attending the meetings together with the Commission. This was until recently, let's say, the main contact point with the energy community. But now with the implementation of the clean energy package, ESA has been involved or has been assigned decision-making powers on these terms and conditions and methodologies whenever contracting parties or a state of the energy community is affected together with a new member state. So if there is if in such situations, ESA will decide, and in view of this forthcoming decision-making powers, there is now more direct contact with the energy community on working level. And afterwards, well, there will be a formal contact in terms of we need to consult the energy community regulatory report if we take decisions. Cases, I think about more than 40 cases before the Board of Appeal, and about, I think, 30 cases before the General Court, and I think three cases before the Court of Justice. So actually 3 cases, but two cases are joined, so actually two appeal cases.
All right, I look at the audience. Just before we go to you, just a question back to Professor Zosniak. Is it your experience that in areas where there was a Board of Appeal deciding before the case reaches the General Court, that the file can be dealt with more quickly because you already have a decision, so that alleviates the burden of those many cases in the area? Is that so? Question back to you. Oh, sorry.
No, I think because it's very.
There is a Board of Appeal deciding. So does that speed up the procedure at the General Court if you have already the file and the previous decision? Not really?
No.
No, because in the quick, I would say, the quick at least would be, from my position, my view, that the court trust Board of Appeal. Not to say trust.
Rely on the Board of Appeal, which it should not. No? Yeah.
Go ahead.
Thank you. Melanie Lumatic from the University of Vienna. I have a very technical question, if I may. You mentioned the 70% target. I was just wondering, 70% of the whole interconnection capacity of the country or of the whole infrastructure capacity of the country?
Well, it says critical network elements. These are elements which are critical for cross-border trades. So in principle, these are the interconnectors, the line connecting. In fact, the bidding zones are reflecting member states' borders at the moment. So the bidding, except with Sweden, where you have several bidding zones in one country is actually one bidding zone. So the connections between the countries, that's the typical line for the 70%. However, you have also internal lines which are relevant for this cross-border exchange, and there you also need to provide 70%.
Okay, thank you. And if I just may, a follow-up question. And if we then follow the recommendation of Acer to adjust the bidding zones according to the actual capacity they have, would this then lead to more and smaller bidding zones? First question. And after that, and assuming that we then have more bidding zones within a country, because the connection within the country is also not at its maximum, then do you then have to have market coupling within the country between the different bidding zones?
Yeah, I mean, the market coupling is European-wide. Even now, you couple the European market to one single market in Europe, and in that sense, it would not make a difference whether you couple the entire the zone of one member state or multiple zones of one member state. But indeed, it would lead to more bidding zones.
All right, thanks a lot. I look at the audience. There's one final round of questions. I have three very brief questions to wrap this up, but that is not to foreclose any questions that you may still have. So last chance to. Okay, my last three very brief questions are, number one, on the territorial reach also connects to what you discussed. So you also covered the states of, or your competence covers the states of the energy community states. But you had a map up there, and we also saw there was Moldova on it. There was still the UK on it. There was even the so the European part of Turkey on it. Is that a coincidence, or is this essentially the reach of cooperation of the energy, so the territorial reach of the cooperation zone for energy regulators? Do you cooperate with the UK and Western Turkey?
Well, with the UK, you have the trade agreement under which, well, we don't really cooperate. Yeah? I mean, there is the trade agreement, but
and there is no competence of the agency or advisory role.
No competence.
Okay. Yeah. For neither of those, also not Turkey,
no,
Moldova. Okay.
Turkey not. After member states, there is, well, competence. It's rather an obligation. Norway actually affects only Norway, and Norway, the approach in Norway is to implement the energy community acquis in a way that still Norway and the EFTA Secretariat adopts decisions, but the ACER prepares a draft for them. So when they implement, for example, terms and conditions, the EFTA Secretariat asks ACER for a draft on the basis of which the EFTA Secretariat authority takes a decision, on the basis of which then the Norwegian regulator takes a final decision.
My second question, as a consumer, I have no understanding of energy markets. Why can we not bring prices down? This is something that I'm puzzled about, and I still don't understand. And to make this more specific, if I understood you correctly, you said the market correction mechanism had no measurable effect. Is that what you said? And my question is, why? Is it because there is no alternative to the gas power plants that are responsible for the hike in prices, or what's the reason? What is the reason for the ineffectiveness of the correction mechanism, and do you have any alternatives?
Yeah, I'm still not sure whether the market correction mechanism is ineffective, but I think the situation of gas supply changed compared to the crisis. As far as I know, it's not yet as critical as we had it in the wake of the war in the Ukraine. So it flattened a bit, but still, gas is indeed a driving force also for electricity prices, because in the end it's merit order list. In the end it's the last power plant that feeds in, and the gas power plants are those who are readily available. So if you need quickly to generate power, then this can be done easily with gas power plants. So there is still an impact of gas power plants on the electricity price. And as far as there is no it's an entire...
I understand, but why after 2 years into the problem why is there no alternative to the gas plants? Why is there no hydrogen, no coal, no atomic power plant generation? I don't understand it.
Because demand is too high.
Because the demand
is too high and too inflexible. I mean, that's the.
All right, and the liquid gas is too expensive.
Yeah.
All right. Okay. Thank you for enlightening my consumer understanding. And if I understand correctly, that will remain so. So there is no. If I ask you for an alternative to this mechanism, there is no perspective.
No, I don't see it.
Okay. Last question, and then I'm really done. And that connects to the question of alternatives. Is Acer in any way involved in the in current developments, such as the COP28 conference that is currently going on? So do you provide advice to the Commission or to anyone in that context? Also, for example, taxonomy regulation. I saw it on the website. That's why I'm asking that it's part of what you have up there, but I'm not aware, and I would be interested in how far are you involved in advising Commission, other agencies, also the development of hydrogen infrastructure. So all those topics that are currently around, do you have any role to play in that?
Well, we do advise the Commission and policymakers. I'm not aware of any advice in terms of COPE. Yeah, of course, also in terms of infrastructure, but not that much in terms of, well, it's rather the transmission infrastructure, but not that much infrastructure, generation infrastructure. Here you can only provide general advice, but then and provide or signal the potential risks, having offshore, how to integrate the offshore capacities into the European network. I mean, on that we do advise, but we do not advise you should build offshore, you should build hydropower plants. That's outside.
No, of course. But for example, in the preparation of the taxonomy regulation, the green investments in atomic power, you were involved. Question mark? Were you involved?
Not that I know. I mean, the mix of energy mix, it's up to the member states. Yeah, so it's a prerogative under the treaty, Article 194, to define their energy mix. So for us, it's a kind of given. Yeah? Of course, we promote the transition to renewables and try to facilitate the integration of renewables, but it's not for us to give recommendations for member states which energy source to select.
So you're also not flying to Dubai?
No.
Okay. Thank you very much, Dr. Tremmel, for the presentation, for coming here, for giving us the opportunity to learn more about energy regulation. I thank you very, very much for being here. And to all of you, thank you also for coming. Again, thank you for having for sponsoring the buffet, and that is die Überleitung dazu. Es gibt, glaube ich, noch was vom Buffet. Gehen Sie nochmal hin, verzehren Sie es restlos und herzlichen Dank. Schönen Nachmittag. Auf Wiedersehen.